Good day. I'm Kirtana Ravindran. 289507 will be presenting the summary of this case study. In this case, Bank Pembangunan Malaysia Berhad is known as the plaintiff P. Ibu Kota Reti Sdn Berhad is known as D1, while Low Chak Hong is D2, the defendants. Ibu Kota Ductile Iron Pipe Industries Sdn Berhad is the borrower. Plaintiff filed an application via Enclosure 9 for summary judgment against defendant. Plaintiff provided two loan facilities, which are the term loan facility of up to Rm 75 million known as first facility and the credit facility of up to 55.48 million, which is the second facility. Second facility is divided into three types, which are term loan 1 up to Rm 22.8 million, term loan 2 up to Rm 15.2 million, and revolving credit up to Rm 18 million. The security documents executed by the plaintiff and the borrower for the first facility are letter of offer, letter of changes, term loan facility agreement, debenture, assignment of performance bonds, assignment of licenses and permits, assignment of insurances, assignments of contracts, assignments of contract proceeds, assignments of sales and purchase agreement, and letter of changes. As for the second facility, the executed security documents are letter of offer, letter of changes, facility agreement for term loan facilities and revolving credit facilities, debenture, second fixed and floating charge for term loan facilities and revolving credit facilities, deed of assignment by way of security, supplemental deed of assignment over the project land, supplemental deed of assignment of payment, supplemental facility agreement, second supplemental facility agreement, and letter of changes. As of 31st January 2017, the borrower was in arrears on the first and second facilities for a total of Rm 128,308,079 and 64 cents. Plaintiff's attorney sent a notice of demand on 10th March 2017 demanding payment of the specified amount within 14 days of the notification date. Plaintiff's attorneys sent a notice of termination dated 16th May 2017 to the borrower discontinuing all facilities with immediate impact and requiring payment of the entire outstanding balance of Rm 197,937,015 and 40 cents within 14 days from the date of the notice. Thank you.
Good day to Doctor and everyone. Today I would like to present the issue raised by defendants. Firstly, plaintiff failed to demonstrate the principles, method of calculation and the effective cost of fund rate in the notice of demand dated on 10 March 2017 to the borrower and the notice of termination dated 16th May 2017 to the borrower. Secondly, plaintiff failed to inform the defendant on the charges to the effective cost of fund, which was outside of the defendant's knowledge and concern. Next, the defendant's liability should be apportionate to the other security held released by plaintiff. Lastly, plaintiff has appointed a receiver and a manager has not fully disposed of the security held. Plaintiff is therefore precluded from filing a suit against the defendants. To sum up, none of the issues raised by the defendant are tribal issues. All of the issues advanced by them has been answered in a favor of plaintiff based on the terms and conditions under the security documentation and the guarantee documents. There is no reason for this suit to go for trial as no further facts could be urged which could throw light upon the security documentation and the guarantee documents that are to be controlled. The defendant do not dispute their liability pursuant to the respective guarantee document. They will only dispute the amount claimed but have to fail to prove the same. Thank you.
Good day everyone, my name is Gaurati Kalisalvan and my mention number is 278088. So, I will be answering for the question 3, which is, does the plaintiff have the right to enforce the guarantee provided by defendant due to the loan facility being in default? In this case, Bank Pembangunan Malaysia Berhad is the plaintiff and Ibu Kota Realty Sdn Berhad, which is IKR, and Low Chiak Hong LCH, are the defendants. The bank supplied IKR with a loan facility for which LCH has issued a guarantee. The loan facility, however, has subsequently fallen into default, and the bank has now initiated a lawsuit against the defendant to execute the guarantee. The borrower had induced the first and second facilities to be in arrears in the amount mentioned in the slide as on 31st of January 2017. Plaintiff attorneys submitted on demand notice on March 10, 2017 demanding payment of the above mentioned sum within 14 days of the notification date. The borrower, on the other hand, never contested or challenged the above mentioned notice of demand and thus failed to pay it. Furthermore, according to the information in the affidavit, the receiver and manager designed by the plaintiff over the borrower are still in the place, are attempting to sell the land and building as well as plant and machinery on the project land in a single transaction. The plaintiff, however, is not barred from calling the survey and filing this complaint against both defendants to recover the whole unpaid amount under the first and second facilities. Furthermore, the defendant relied on other sum case in written submission, but this did not aid them in court because the case was not similar to the defendant circumstances. There are three possible explanations to begin each of those authorities' establishment the legal principle that illegitimate claims against the guarantor must be made prior to filing litigation. The filling of the writing and service was insufficient to satisfy the guarantee. Second, the fact of this case not to belong in the same category. Both defendants received notice of demand dated 16 May 2017, coincident with the borrower's notice of termination prior to the filing of this suit. The principal sum interest late payment, interest and charges were all specified in the both notice and the demand to the defendant. Third, during the relevant period, the defendant never contested or challenged the notice of demand issued to them based on its merit or content. Lastly, since the loan facility is in default, the plaintiff have right to enforce the defendant guarantee. So that's all from me. Thank you.
Good day to Doctor and everyone. I am Vinny Kulvesian with metric number 279799. Today, I would like to present about the question 4, which is, do defendants have the right to sue the plaintiff when the plaintiff failed to inform the defendants on the changes of rate which they claim that the changes were outside of their knowledge and concerns? Give your opinions. Yes, in my opinion, I think the defendants have the right to contend plaintiff when the plaintiff failed to inform the defendant on the changes of rate which they claim that the changes were outside of their knowledge and concerns. This is because there are certain rights accorded to you as guarantor before and after signing the contract of a guarantee. The law confers a guarantor 4 rights which are right against itself, right against creditor, right against the principal debtor, and right against co-guarantors. In this case, the right to be informed is the right that they should apply. If something takes place between the creditor and the debtor, something that is not natural to be expected, as in the case of Hamilton versus Watson, for example, Ravindra obtained an overdraft facility of 200,000. Mukhali stand as a guarantor for the loans. 2 years later, Ravindra requests the bank to increase the loan to 300,000, to which the bank agreed without the knowledge and consent of Mukhali. In this case, Mukhali in only liable up to 200,000. She is not responsible for the increased amount of the overdraft facility. In addition, the right is also known as the right to be notified of contract changes. The lender must give the guarantor full written details of any changes to the credit contracts that either increase the borrower's obligations or shorten the amount of time the borrower has to pay the debts. The lender must give you this information within 5 working days after the change. Based on this case study, in respect of the guarantee document executed between P and the defendants for the first facility, this right also was agreed between the parties. Any extension, renewal, alterations of variation of and or amendments, additions or substitution to any of the provision of the TF facility agreements and or the obligation undertaken by the borrower or any security or other guarantee and indemnity or renewal of the TF facility or any arrangement made after the executions for this guarantee or any dealing between the borrower and the bank with or without notice to the guarantor and whether with or without the consent or knowledge of the guarantor in the agreements between the borrower and the banks for making of advances or otherwise giving credit or affording banking facility to the borrower by the bank. In this case study, Ibu Kota Realty Sdn Berhad and Loh Jiang Hong are the guarantors for the loan facility provided by Bank Pembangunan Malaysia Berhad to the borrowers, which is Ibu Kota Duk Iron Part Industry Sdn Berhad. Issue raised by the defendants was only to dispute the amount claimed by P. They complained that the amount claimed is incorrect and excessive. P failed to demonstrate the principles, method of calculations, and the ECOF effective cost of fund rates in the notice of demand dated by 10 March 2017 to the borrower and the notice of termination dated by 16 May 2017 to the borrower. P also failed to inform the defendants on the changes to the ECOF rate, which was outside of the defendants' knowledge and concerns. The defendants' liability should be proportionate to the other securities held and realized by P, and P has appointed a receiver and manager and has not fully disposed of the securities held. P is therefore precluded from filing this suit against the defendants. Therefore, I think the defendants have the right to contempt plaintiff when the plaintiff failed to inform the defendants on the changes of rate which they claims that the changes were outside of their knowledge and concerns. That's all from me. Thank you.
My name is Nurfazana Izzati binti Mujibuddin. My metric number is 278459. My part is explain the type of guarantees for defendant 1 and defendant 2 and their liability as principal debtors. The type of guarantee used by defendant 1 and defendant 2 is corporate guarantee. A corporate guarantee is defined as an agreement in which one party, the guarantor, takes on the payments or responsibilities of a debt if the debtor fails to pay the loan. Defendant 1 liability as between the corporate guarantor and plaintiff Bank Pembangunan Malaysia Berhad BPMB, the guarantor shall be liable for the guaranteed amounts under clause 2 as a principal debtor and not merely as a surety in first facility. For second facility, state that the corporate guarantee is in addition to and not in substitution for any other rights or securities with BPMB may have under or by virtue of terms of the facility agreement or otherwise. Defendant 2 liability, a statement of account of indebtedness in first facility is certified by any of the authorized officers of the bank, showing the indebtedness of the borrower of any judgment recovered by the bank against the borrower in respect of such indebtedness shall save for manifest error be binding and conclusive evidence against the guarantors. For second facility, a statement of account in writing showing the indebtedness of the borrower to BPMB, certified by the manager or the accountant or other authorized officer might have quoted by BPMB and shall be accepted by the guarantors and its personal representative and estate as conclusive evidence that the balance or amount shown in is due from the borrower to the BPMB. Thank you.